131-W.
Good morning, Your Honor. Ben Scroggins, 7902 for the petitioner, who is present on Zoom, thanks to
Okay.
his staff.
Oh, thank you. I wasn't sure we were going to see him today because I didn't see the order, but
He is muted.
it looks like we took care of it. Are we ready to argue?
I believe so, Your Honor.
Do we have the attorney from the state?
Judge, it looks like the Vehicular Crimes Unit is just going to be submitting this. Thank you. We'll submit it.
Okay. All right. Mr. Scroggins, I would like you to make an oral argument, seeing as how you're here.
Yes, Your Honor. As you can see, the petition was very simple. I didn't attack everything possible. I only focused in on a couple of issues that I think in this case are very important. The first claim is essentially about the lack of investigation on the part of trial counsel, and what that is based on, and I pointed it out, we did receive trial counsel's entire file on this case, and we produced it as an exhibit in our appendix. And as the court could see reviewing that, it was extremely sparse. But what we did find was that there was an article talking about false positives for methamphetamine based upon use of Vicks. Now, the attorney had that article because we have to presume that he believed that that might be relevant to the case and what he was being told by his client. However, that was never followed up on. There's no indication that he consulted with or obtained an expert to deal with that. Rather, he, according to my client, pressured him to take a plea deal that was offered prior to conducting that complete investigation. Now, what I think is the more important issue for what we're here for today, Your Honor, is this issue about the withdrawal of the guilty plea. I set forth in the petition that when a person is looking to withdraw a guilty plea prior to actually being sentenced, the court is not to look at the merits of the case. It's not a question of whether the plea was voluntarily and knowingly entered. Those are not the considerations. The considerations are whether the person is truly seeking to withdraw that plea and insisting on going to trial. The circumstances under which Mr. Pepperdale was sentenced, Your Honor, he, again, tells me that he had been unable to contact his attorney prior to that date of sentencing. He had some serious issues he wished to discuss with his attorney before that date, and because he was frankly scared, he did miss that hearing. At the sentencing itself, he discussed with his trial counsel withdrawing the plea, and the reason he wanted to withdraw the plea was because he believed that having gone into warrant would negatively impact the sentencing court's decision. As I pointed out in the petition, Your Honor, that there does seem to be some merit to that concern, as the trial court specifically stated that that bench warrant was a significant, well, initially the court said the most significant reason for imposing the maximum sentence and running them consecutive, and then said, well, not the only reason. So I think he had a reasonable basis for wanting to withdraw the plea at that point. When a defendant indicates a desire to withdraw a plea, part of that, looking at the totality of the circumstances, Your Honor, is the court is supposed to canvass the individual to determine if that person truly wants to withdraw the plea and is doing so knowingly and voluntarily. Essentially, it's a withdrawal canvass that's very similar to a plea canvass. And this was brought to the court's attention before sentencing occurred, that Mr. Pepperday was wanting to withdraw the plea. Trial counsel stated that trial counsel wanted to proceed with sentencing, and according to Mr. Pepperday, told him that at this point, being at sentencing, he could not withdraw the plea, and even indicated that the results of sentencing might be more harsh if he did withdraw the plea. The court never questioned Mr. Pepperday. There was never any kind of canvas given to him. It was never determined by the court, by the totality of the circumstances, that Mr. Pepperday wanted to withdraw that plea and would have insisted to go to trial, Your Honor. So, as I said, I think it's a couple of straightforward issues. I think that we're at least entitled to an evidentiary hearing, Your Honor, to find out why trial counsel did not conduct the investigation that apparently they had decided was important enough to begin by at least getting some articles, and to explore whether that withdrawal of the guilty plea should have been granted, given the fact that there was no actual canvas of Mr. Pepperday by the court. And with that, Your Honor, unless you have additional questions, I submit.
Okay, thank you. So under Strickland, the defendant must first show that his counsel's representation fell below an objective standard of reasonableness, and second, that but for counsel's ineffective assistance, he would not have pled guilty. So that is certainly what's being alleged here in this petition. And at this point, if the allegations that have been made in the petition are to be taken as true, I would highly likely find that the representation fell below an objective standard of reasonableness, based not as much on the lack of research necessarily, because I have so little information about that, but certainly based on what appears to have happened during the sentencing or just prior to the sentencing, assuming that those concerns were actually relayed to counsel as stated here today, and counsel's responses were as stated here today. So, and again, falling below that standard of care, certainly the allegations made about what was said prior to the sentencing would have affected whether he requested to withdraw his plea or had pled guilty in the first place. So in this case, withdraw his plea, but the standard is the same. So that having been said, I'm going to grant an evidentiary hearing as to those issues with regard to the reasonableness of defense's the standard, and with regard to whether or not the defendant actually would have asked to withdraw his plea. So then we can go from there, because I don't have enough factual information to make a decision on this. But I do think you've established a likelihood that's high enough that that could be the case that you're entitled to an evidentiary hearing.
Thank you, Your Honor. And given the court's ruling, I would be requesting that we be permitted to engage in some discovery prior to the evidentiary hearing. Would the court like me to put that in a motion to make it official?
I think that would be appropriate unless the state's objecting.
Well, Your Honor, I'm not, this is our vehicular crimes unit. I don't know if they would object to that or not.
I could just do a motion statute.
Yeah.
I'm sorry.
Yeah, I'm sorry. You're right. Go ahead.
Yes, Your Honor. The statute says that we can request it from the court if an evidentiary hearing is granted. So I think, just for the sake of simplicity, if I just do a motion, and that way we can actually lay out what discovery. I don't want to do like a full civil case discovery, but at least maybe a deposition of trial counsel, some things like that. If the court is inclined, I will put that in writing, and then the state can respond if they object.
Okay, that would be best. That way they have a chance to respond. So please submit a written order with regard to this ruling, so everything is nice and clean and we know exactly what the ruling was and why. And then submit the motion on the discovery. And at that point, we'll have an oral hearing on that, and then we'll decide the briefing schedule, or the discovery schedule prior to the hearing date. We won't set it today.
Yes, Your Honor, that makes sense to me. Thank you, Your Honor, and I will send the order over to the state prior to submitting it, just so there's no issues on what was actually decided today.
Thank you.
Thank you, Your Honor.
Page 8, State of Nevada versus Wash, C 382005-2.